we will discuss the topic amendment of the Indian Constitution. The first topic today we are discussing is amendment of the Indian Constitution. Article 368 of the Indian Constitution. Article 368 of the Indian Constitution deals with amendment. Power and procedure for amendment. Power and procedure for amendment. Parliament have law making power, also called as legislative power. Parliament have law making power, also called as legislative power. Constitutional amendment power of the Parliament is called constituent power. Constitutional amendment power of the Parliament is called constituent power. Article 368 deals with both. Article 368 deals with both power and procedure for amendment of the Constitution. It deals with both power and procedure for the amendment of the Constitution. You may get the prelims question. You might get the prelims question. Article 368 deals with A. Power to amend the Constitution. B. Procedure to amend the Constitution. C. Power and procedure to amend the Constitution. D. None of the above. It deals with both power and procedure to amend the Constitution. In the world, there are two types of constitutions. In the world, there are two types of constitutions. Rigid constitutions, flexible constitutions. In the world, there are two types of constitutions. Rigid constitutions and flexible constitutions. Rigid constitutions are difficult to amend. Flexible constitutions are easy to amend. Rigid constitutions are difficult to amend. Flexible constitutions are easy to amend. American Constitution is considered as a rigid constitution. British Constitution is considered as a flexible constitution. American Constitution is considered as a rigid constitution. British Constitution is considered as a flexible constitution. Generally, federal constitutions are rigid. Generally, federal constitutions are rigid to amend. The reason is, in federation, both center and state exist. Both have their own autonomy and space. Both center and space exist. Both have their own autonomy and space. Centers cannot override states and states cannot override center. Center cannot override states and states cannot override center. What we need is an independent arbiter. So, the constitutions which are federal in nature generally will be difficult to amend. Indian Constitution is neither too difficult to amend nor too easy to amend. Indian Constitution is neither too difficult to amend nor too easy to amend. It is a unique blend of Indian Constitution is the unique blend of rigidity with flexibility. It is the unique blend of rigidity with flexibility. Jawaharlal Nehru, the first Prime Minister of India, told, while we want to make this constitution solid and petrified, while we want to make this constitution solid and petrified, we can make it. But there cannot be permanency in such a constitution. While we want to make this constitution solid and petrified, we can make it. But there is no permanence in such a constitution. When the world is in a period of transition, when a world is in a period of transition, what we may do today might not be applicable tomorrow. When the world is in a period of transition, what we may do today might not be applicable tomorrow. The only thing that is permanent in the world, the only thing that is permanent in the world is change. Change is the only thing that is permanent in the world. Change is the only thing that is permanent in the world. Constitution is like a living organism. It should grow. When you want to make something static, it cannot maintain permanency. Say for example, your grandfather wrote a book for your family. He told you should wear a particular type of attire. You should only eat particular type of food. You should follow particular type of custom. You should sleep at that time. Everything is written by him in a book. Everything is completely written by him in a book. Your father might follow it because of his respect towards his father. Will you follow? Think that you are following. Will your future generations follow? Generally they will throw the book out. When the grandfather writes, yes, these are my principles. You can change them according to your times. Amend them. But core values don't change. If he writes like that, there is a possibility that the book will last long. There is a possibility that the book's sanctity will be maintained. In the same way, constitution, when you want to make it very strong, static, it won't be a permanent constitution. You will be seeing most of the countries in the world having their own constitutions changing all the time. Russian constitution, most of the times constitutions change. But Indian constitution accommodated for change. The simple example, we have more than 101 constitutional amendment acts. The reason is, according to the changing times, constitutions will also change. The needs of the people will also change. But the values of the constitution should not change. But the values of the constitution should not change. So for that reason, Article 368 provides for power and procedure. The only article in the Indian Constitution, which deals with amendment power procedure is Article 368. Article 368. There are three types of amendments. Amendment by simple majority. First type is amendment by simple majority. Second type is amendment by special majority. Third type is amendment by special majority along with the ratification of half of the states. There are three types of amendments. Amendment by simple majority. Second is amendment by special majority. Third is amendment by special majority along with the ratification of half of the states. Indian Constitution provides for three types of amendment. Amendment by simple majority means the majority of the members present and voting. In the members present and voting, if the majority likes it, it's called amendment by simple majority. For example, the total strength of the house is 100. On the particular day, 65 present. Out of 65, if the majority accepts it, it is done. That's called amendment by simple majority. Second type of amendment is amendment by special majority. Amendment by special majority means 2/3 of the members present and voting should accept it. 2/3 of the members present and voting should accept it. For example, think that this is a rainy day. This is a rainy day. The total strength of the class is 100. The total strength of the class is 100. Because of rain, only 30 came to the class. Only 30 came to the class. And 2/3 majority means 21 liked it. 21 supported the bill, constitutional amendment bill. If I pass it, what about the remaining 79 people who have not attended? Remaining 71 people who have not consented for it? Okay, for that reason, in the amendment by special majority, it was told that 2/3 of the members present and voting, and this should be absolute majority of the total strength of the house. Majority of the total strength of the house. That means this 2/3 should be minimum 50% of the house plus 1. That means the government or the speaker or the particular constitutional amendment should not take advantage of less quorum and pass a constitutional amendment bill. There are two conditions in special majority. First condition is 2/3 members present and voting. This 2/3 should be the majority of the total strength of the house. Total strength of the house, for example, 545. 50% plus 1. 50% plus 1 should be minimum. Then only constitutional amendment bill will be passed. This is called special majority. Okay, because generally most of the times quorum will not exist. Minimum quorum to conduct the house is 10%. Most of the times even 50% will not present. At that time constitutional amendment bill should not be passed, because for example, say Mr. X is the Prime Minister. He wanted to make an important change in the constitution and he wanted to introduce the bill and pass the bill when there is less quorum. So the government should not be whimsical in amending the constitution. The government should not be whimsical in amending the constitution. For that reason, the provision for special majority was given. That means 2/3 of the members present and voting. And this 2/3 should be absolute majority of the total strength of the house. That means 50% plus 1. Say for example, in the class there are 100 people, only 30 are present. Then the bill cannot be passed. And if the bill has to be passed, 50% means 50 people plus 1 and 51. That means 51. Along with 2/3 members present and voting. Both the conditions should be fulfilled. And the third type of amendment. The third type of amendment means special majority along with the ratification of half of the states. Special majority along with the ratification of half of the states. That means not only special majority of parliament, but also half of the state legislatures must also ratify it. Half of the state legislatures must also ratify it. When the interests of state are involved, when the provisions which affect the state is also involved, the consent of the state legislatures is also compulsory. Okay. So half of the ratification of the state legislative assemblies, state legislatures is also a must. So simple majority, special majority along with the ratification of half of the states. Simple majority articles, say for example Article 5, Article 169, Article 239 capital A. Article 5, Article 169, Article 239 capital A. Article 169, creation or abolition of a legislative council in a state. Say for example, in one state, state assembly passed for creation of legislative council. It will go to the parliament. Parliament can by simple majority can create a legislative council. Article 169, creation or abolition of a legislative council in a state is very easy for the parliament because it requires only simple majority. Okay. Special majority, amendment to fundamental rights, amendment to directive principles, most of the important sections of the parts of the constitution, articles of the constitution. Apart from that, special majority along with the ratification of the half of the states. Say for example, election of the president, extent of the executive power of the president, that is of the union, and extent of the executive power of the state, Schedule 4, allocation of seats in Rajya Sabha, Schedule 7, to change a list, union list, state list, concurrent list, Schedule 7, because which affect the state interests, and jurisdiction of the Supreme Court, High Courts, Supreme Courts and High Courts, and also in order to amend Article 368 itself, states' consent is necessary. Ratification of half of the states is necessary to amend Article 368 itself. So there are three types of amendments: simple majority along with the ratification of half of the states, In special majority along with the ratification of half of the states, you have some important provisions which states will get affected. So, for that states consent is also necessary. A bill to introduce constitutional amendment. A bill for constitutional amendment can be introduced either in Lok Sabha or in Rajya Sabha. A bill for constitutional amendment can be introduced either in Lok Sabha or in Rajya Sabha. There cannot be a joint sitting for constitutional amendment. There cannot be a joint sitting for constitutional amendment. Constitutional amendments can be reviewed by the judiciary. There can be a judicial review for constitutional amendments also. For example, National Judicial Appointments Commission, NJAC, National Judicial Appointments Commission was declared as unconstitutional. The particular 99th constitutional amendment was declared as unconstitutional by the judiciary. So, there can be a judicial review for the constitutional amendment also. And the most important amendment to the Article 368 is 24th Amendment. 24th Amendment. 24th Amendment Act 1971 made it compulsory for the President. 24th Amendment Act 1971 made it compulsory for the President to give his assent for the constitutional amendment bills. 24th Amendment Act 1971 made it compulsory for the President to give consent for the assent for the constitutional amendment bills. This is Article 368, power and procedure for amendment of the Constitution.